Good evening, everyone. Welcome. I'm Jennifer Mnookin, and for those who don't know me, it's my great pleasure to be dean here at UCLA Law School. Can everybody hear me way in the back? All right. So thanks for coming to Whither the Court. It's our 18th annual review of the major trends and cases before the Supreme Court of the United States. Before we begin, I do want to acknowledge that today's event takes place on the traditional, ancestral, and unceded territory of the Gabrielino and Tongva peoples. As we are members of a land-grant institution, we at UCLA want to pay our respects to the ancestors, elders, and relatives past, present, and emerging. I'm very glad that all of you can be with us tonight. I think we've got a mixture of students, alums, and friends, and you are really in for a treat. Today's stellar panel includes lawyers and scholars who are sophisticated court watchers, masters in their field, and often advocates who argue before top courts in the nation or who influence those courts with their own research and writing. Now, this certainly includes our special guest, Dale Ho, who's sitting on furthest to my right here. That is not political, that's descriptive. He's the director of the ACLU's Voting Rights Project. He was also among the attorneys who earlier this year argued the case of Department of Commerce versus New York at the Supreme Court, successfully challenging the Trump administration's effort to add a controversial citizenship question to the census. Now, UCLA Law, in a sense, played a role in arguing another notable case before the court last year, in Iancu versus Brunetti. That was about trademark protections for a clothing line whose name I'm going to spell, not say, because it was F-U-C-T. And Professor Stuart Banner and the students in his Supreme Court clinic submitted an amicus brief arguing that the ban on registering immoral or scandalous trademarks is a relic that should be lifted. Now, Professor Banner is quite familiar with this issue. Along with Professor Eugene Volokh, who is on our panel tonight, Stuart and his clinic students had researched and written the briefs in a similar Supreme Court case, Mattal versus Tam, which their legal team won just 2 years earlier. What's more, the lawyer who argued the FUCT case is John Summer, an alum from the UCLA Law class of '82. And building on the precedent that Stuart, Eugene, and our students helped set, Summer won a 6-3 decision in favor of his client in June. Now, UCLA was on the other side, too, in this case, because if you know the name of the case, Iancu versus Brunetti, that would be Andre Iancu, who's the current head of the U.S. Patent and Trademark Office, and he graduated from UCLA Law School in '96, and also taught patent and trademark here for many years, and was also a partner at here in LA. Now, separately, Professor Joanna Schwartz's groundbreaking work on police immunity and indemnification was cited last term by Justice Sotomayor in her dissenting opinion in the civil rights case Nieves versus Bartlett. So these are a few examples. I could go on. And of course, the Supreme Court is not only or even primarily about the ways that UCLA Law is making its mark or connection, but it is nice to see the ways that our faculty and even our students are having the chance to have these kinds of influence. Now, this event's special to UCLA Law School. It's been going on for 18 years. That's pretty significant. And it's held in honor of also one of our alums, Allan Lebow. He was a brilliant member of the class of 1972 who practiced corporate and bankruptcy law and whose family chose to honor his memory and his tragic early death in a plane accident by endowing this annual event. And so I want to thank the Lebow family for their generous support that makes this event, as well as the reception you enjoyed beforehand, possible. I'm very excited to turn things over to our panelists. I already introduced Dale Ho, and we're just so delighted that he's with us for a couple of days here at UCLA Law School as the Margaret Levy Public Interest Law and Policy Fellow. We also have Jennifer Chacon, who is a leading scholar of immigration law, constitutional law, criminal law, and social justice. Her work focuses on questions surrounding citizenship, international borders, human trafficking, and the connection between crim law and immigration. She also serves as a member of the American Law Institute and the advisory committee of the American Bar Foundation's Future of Latinos project in the United States. Eugene Volokh, who's next to her, is the Gary T. Schwartz Distinguished Professor of Law here at UCLA, and he's one of the leading voices on the First Amendment, as well as one of the scholars who's most cited by courts today. Through its First Amendment amicus brief clinic, he also works with our students to file briefs, and occasionally our students also get the opportunity to deliver oral arguments in cases before state and federal courts around the country. He's also a very well-known blogger as the creator of the Volokh Conspiracy. Next to him, we have Jocelyn Samuels, who's the executive director of the Williams Institute on Sexual Orientation and Gender Identity, Law, and Public Policy at UCLA. We're very proud that the Williams Institute is here and in fact was the first law school-based space for thinking about these issues of sexual orientation and gender identity. Jocelyn came to us from Washington, D.C., where she'd been acting assistant attorney general for civil rights, and she'd also worked as director of the Civil Rights Office in the Department of Health and Human Services in the Obama administration. And Professor Winkler, last but very much not least, he's made so much of today's event happen as he's helped with Whither the Court, with organizing Whither the Court every year. So thank you for that, Adam. Adam is a leading constitutional scholar and one of the country's leading experts on Second Amendment and gun rights. He also, in addition to his very well-known book in that field, his recent book on corporate rights called We the Corporations. Well, let's just say if you haven't already read it, you should, right after tonight, you should make sure you go out and get it and read it. It received very wide acclaim, way too many prizes for me to list here, including being named as a finalist, in fact, the only law book that was a finalist for the National Book Award in 2018. So you are clearly in for a treat. Enough from me. Let's hear from our very distinguished panel and give them a very warm welcome. Thank you for being here.
Thank you, Dean Mnookin, for that wonderful introduction, and thank you to Elsa and for everyone here at UCLA Law who's made this event possible tonight. So Whither the Court is our somewhat stuffy, lawyerly name for our annual Supreme Court review. And the idea of whither implies a direction. What direction is the court going? Where has it been over this past term? And where does it seem to be heading in the coming term that begins in October? And so in that spirit of identifying and explaining and teasing out the trends in the Supreme Court, we're going to talk about some of the major cases of the last Supreme Court term that ended in June. Cases that include the Census Case that Dean Mnookin mentioned, in which the court rejected President Trump's effort to add a citizenship question to the census. We'll talk about Rucho versus Common Cause, an important partisan gerrymandering case decided by the Supreme Court this year. There's a case involving religious freedom. We have the Iancu versus Brunetti First Amendment case, and an interesting case too on administrative deference, an issue that's very hot in the Supreme Court these days. And we'll also look forward to some of the big cases coming in the next term that begins next month. There's a series of cases that ask whether Title VII's prohibition on discrimination because of sex applies to discrimination on the basis of sexual orientation and gender identity. We'll talk a little bit about Trump versus NAACP, where the court will decide whether the administration's decision to wind down the deferred action for childhood arrivals, the DACA policy, is reviewable by the court and lawful. And hopefully we'll get a chance to talk about the court's major Second Amendment case that it has coming before it. That case is interesting in part because it includes a brief filed by 5 senators that basically tells the court the world is watching, you're losing legitimacy in the eyes of the public, and it's time to straighten up and fly right, which gives sort of a little different definition of whither the court. The brief seems to suggest that the court its legitimacy is dying on the vine. And so hopefully we'll get a chance to talk about that too. Certainly it was a new Supreme Court this term. We had Anthony Kennedy retire, and he was replaced, even though Anthony Kennedy was the longtime swing vote on the Supreme Court. Time magazine once put him on the cover, calling him the most powerful man in America. But he resigned and was replaced by Brett Kavanaugh after a rather bruising confirmation battle. And although Justice Kavanaugh was expected to join with Justice Neil Gorsuch, the other appointee of President Donald Trump, to create a more solid conservative bloc, at least this year, there were some surprises in this regard, and some surprising outcomes and surprising coalitions. Instead of what many thought would be a sharp turn to the right, this term actually saw the court's more liberal members of the court come out with quite a number of victories, some of which were highly unexpected. And in about half of the 5-4 decisions, the liberal members found themselves in the majority. And one of the biggest surprises of the term, well, let's just say the biggest surprise of the term, came in the case that our special guest, Dale Ho, argued before the Supreme Court, the Census Case. Dale, welcome to UCLA. Congratulations to you for pulling off such a big surprise. Generally, if there's a big surprise like this, it only happens with excellent lawyering. So congratulations to you. Could you tell us a little bit about the Census Case, the legal issues that were involved, and what the court decided?
Sure. So I'll just back up and provide a little bit of context about the case. The decennial census is one of the few functions of the federal government that is expressly spelled out in the Constitution. It is sort of a pillar of the way that our democracy works. Representation in the House is apportioned among the states based on the total population counts as determined by the census, and then states in turn use population counts to draw district lines within the state for purposes of congressional districts, state legislative districts, local jurisdictions do so as well, and census counts are the basis for the distribution of about $900 billion in federal funds annually. The census has not featured a question about citizenship put to every member of every household in the country since 1950. Now, there have been sample surveys that the Census Bureau uses to try to estimate the number of citizens and non-citizens in the country, but for almost 70 years, no door-to-door, house-by-house inquiry of every person's citizenship status. And that decision after 1950 to abandon a citizenship question on the census accompanied a sort of advance in the science of survey research, and understanding by the professionals in this line of work that the more complicated you make a survey, the longer you make it, the more intrusive you make the questions, the fewer responses you get to the survey, the fewer accurate responses you get to the survey, and that you're better off with, when you're doing this kind of survey, if you're not going to statistically try to correct for those kinds of issues, non-response or inaccurate response, is to make a survey as simple as possible. So the census questionnaire after 1950 went from a very long form that had dozens of questions to something short and simple. And the refrain you've heard in the last few censuses is simple. It's simple to fill out 10 questions. Now, the census has historically undercounted non-white populations. So every time there's a census, the Bureau goes out and tries to estimate the total population, try to figure out if it got anything wrong. And every decade since the Census Bureau has engaged in this practice, it has determined that to the best of its knowledge, it has undercounted African Americans, it's undercounted Hispanics, and it's undercounted Asian Americans. The last census, actually, though, the 2010 census, resulted in an overcount of the total population, because notwithstanding all of that, there was an overcount of the non-Hispanic white population, which more than swamped the undercount of those individual minority populations. The case arose from a decision by Commerce Secretary Wilbur Ross. The Census Bureau is located within the Commerce Department. To add a citizenship question, the decision was made public in March of last year. The purported rationale for adding a citizenship question to the census was that it was necessary to enforce the Voting Rights Act of 1965. The decisional memo from Secretary Ross dismissed any notion that adding a citizenship question would reduce participation in the census, notwithstanding the Bureau's own estimate at the time that about 6 million people would not respond to the census if the question were added. Over this summer, the Bureau upped that estimate to about 9 million people who would not respond. So don't take it from me, take it from the administration itself. Just to put that number in perspective, and I said this earlier today at my earlier talk, so apologies if I sound like a broken record. 9 million people is more people than in our 11th most populous state, New Jersey. If you put them all together and made a state out of 9 million people, that state would have 12 members in the House of Representatives and 14 votes in the Electoral College. So losing 9 million census participants is a pretty big deal. And they're not, that 9 million would not be evenly spread throughout the country, right? So it's not like, you know, every state would lose the same proportional amount of population. What the trial court found in our case is that non-citizen populations, because they are unevenly spread in the country, a citizenship question would cause particular states to be at high risk of losing a seat in Congress, including California, Florida, New York, Illinois, Arizona, and Texas. And then, of course, within those states, urban areas, more diverse areas that have larger percentages of non-citizen populations would lose representation, which would then flow out to rural, more sparsely populated areas, disproportionately white areas. The Secretary's decisional memo, despite being warned by the Census Bureau that this was a risk, denied that that was the case, claimed that it was necessary for purposes of Voting Rights Act enforcement, even though for the entire life of the Voting Rights Act, there has not been a question about citizenship on the census. We sued, alleging violations of the various violations of the Constitution and the Federal Administrative Procedures Act, and the case proceeded from there.
And tell us what happened in the Supreme Court. How did the court rule on it?
Sure. So the trial court found multiple violations of the Administrative Procedures Act. Basically, you could group those into two big buckets. One, that the Secretary's decision was substantively wrong, that the evidence before him did not support the notion that a citizenship question would in fact improve or could improve Voting Rights Act enforcement in any way. And then a series of procedural arguments, the most important of which was that the Secretary had been dishonest, that in fact he did not want to improve Voting Rights Act enforcement, but that the decision to add a citizenship question was made for other reasons which were never disclosed to the public. And what we learned in the case through discovery was that just 2 months into being Commerce Secretary, Wilbur Ross was already writing angry emails to his staff demanding to know why a citizenship question had not already been added to the census. This was almost a year before the decision was made official and the Voting Rights Act justification was publicly disclosed for the first time. So with those two sets of arguments, we went up to the Supreme Court. The Supreme Court reversed the district court with respect to the first issue, finding that substantively you could think that adding a citizenship question could possibly assist with Voting Rights Act enforcement. Now, as a voting rights lawyer, I have to tell you that's, in my view, quite wrong, but the standard of review there for the substantive validity of the agency's decision is quite generous to the agency, so one can see why the Supreme Court might arrive at that decision. But 5 members of the court agreed that the evidence showed that Secretary Ross was not actually interested in enforcing the Voting Rights Act, that was not the reason why the administration wanted to add a citizenship question to the census, and the failure to be honest about that and to supply only a pretextual justification for the decision, the Supreme Court found violated the Administrative Procedures Act and enjoined the administration from adding the question.
Now, one of the interesting things about this case is that after oral argument, most court watchers thought that this case was going to go the other way, that the court would uphold the inclusion of the citizenship question. There have since been some reports that Chief Justice Roberts may have changed his vote at some point after the conference in this case. Any thoughts about why that might have been? Why the change of heart at some point on this?
Great lawyering.
Persuaded.
I thought oral argument had gone so well that it was inconceivable that we'd lose a single justice. I didn't think that. I was not as pessimistic after the argument as a lot of the coverage was, and the reason is because I didn't detect a tremendous amount of hostility from Chief Justice Roberts, who I think we all viewed as the, gettable vote for our side if we were going to prevail. All that being said, I understand why the coverage was what it was. You walk into that argument expecting us to be the underdog. Nothing that was said during that argument suggested that we were not the underdog. So your initial, presumption about which way the court is going to vote, there was nothing that happened during that argument, or no signal from the justices to suggest that presumption might be wrong. So I understand that. All that being said, I didn't detect a lot of hostility from the chief. The only time he seemed incredulous was when the Solicitor General was arguing that we didn't have any standing, and kind of pushed back aggressively on that notion. I've seen the report from Joan Biskupik. It's notable for not speculating or containing any source suggesting when or why the chief may have changed his vote. Now, there were some post-argument revelations. In particular, our co-counsel in the case, which was representing plaintiffs in state court litigation in North Carolina, challenging the districts there as partisan gerrymanders in violation of the North Carolina Constitution. I know we're going to talk about partisan gerrymandering later. Found a trove of documents belonging to a man named Thomas Hoffler, who had recently died and was for decades kind of the gerrymandering guru for the Republican Party. Pretty much anywhere there was litigation over district lines, they were lines that Dr. Hoffler was involved in some way in drawing. And what was remarkable, two documents were remarkable in Dr. Hoffler's files. One was a memo that he had written writing that, and I can explain this in more detail, but just to give the top line, writing that to facilitate a redistricting strategy that he was asked if it was possible to employ to the benefit of Republicans. He said it would only be possible if a citizenship question were added to the census. And if that happened, we could use a redistricting strategy that would, in his words, quote, be advantageous to Republicans and non-Hispanic whites, and would be disadvantageous to Hispanics. A second document on Dr. Hoffler's hard drives was a first draft of a letter from the Department of Justice requesting the inclusion of a citizenship question to protect minority voting rights, to help with the Voting Rights Act enforcement. Language from Dr. Hoffler's draft appeared verbatim in an initial draft of the Department of Justice's letter requesting a citizenship question from the Commerce Department. So what we had was a trail of documents in clearer terms than we had seen up until that point, making pretty clear that some folks who were involved in this decision were aware that adding a citizenship question would do exactly the opposite of what the administration claimed it would do. It would not protect minority voting rights, but rather was a tool that could be used to dilute them. We put those documents before the court in a motion requesting a remand for fact-finding as to the significance of those documents. Now, those documents are not referenced in the majority opinion or any opinion in the case, so it's hard to say whether or not they had any effect, but they were certainly consistent with the argument that we had been making from the beginning that the administration's rationale was protectual.
Wonderful. Okay. Any perspective they want to add on this case? Panelists?
I mean, I would just say, and this is not particularly relevant to the case, but this is a wonderful outcome to, avoid suppressing the willingness of 9 million people to respond to the census. But one way in which the census continues to be inadequate is that it does not ask questions about sexual orientation and gender identity. And during the Obama administration, there were efforts to add those types of questions to the census, which would have enabled researchers, including at the Williams Institute, to really understand the way in which LGBT people participate in federal programs, where they live, what levels of education they have, and all of the different categories of information that the census requests. So I would say the defeat of a citizenship question is a wonderful effort and will protect the census from being hijacked for nefarious means, but it does not mean that the census is the kind of complete assessment of the characteristics of the American people that I think it was intended to be.
Well, so let me ask this: what if there was some evidence that asking sexual orientation or gender identity would lead some people not to want to answer the census?
I'm not aware that there is any such evidence,
Right,
and of
it's
course,
hard to figure
every
it out.
question on the
Right.
census is a voluntary one. So
The same thing could have been said of the citizenship status, right? It would be really useful from a data perspective if we thought we'd get good data to ask about citizenship status. In fact, it's possible, at least under one reading of the 14th Amendment, the government ought to know how many citizens there are, because actually the 14th Amendment requires Congress, not that Congress has ever done it, requires Congress to diminish representation of states that deny the vote to certain citizens. So to fully enforce that, you might want to have this information. But my understanding actually is that many survey takers do think that once you ask about questions that many people find very sensitive, then they actually are less likely to answer that, right?
So, I mean, I do think that the Census Bureau conducts extensive testing before it puts questions on the census to be able to evaluate its impact. I'll also say there are government surveys that do ask about sexual orientation and gender identity, and there's never been a finding as to any of those that it suppresses response rates.
And I think it's important to note how narrow the Supreme Court's
Right,
ruling
right.
was here, right? They didn't say you can't add a
Right,
citizenship question.
right, absolutely.
They said if you want to add a citizenship question, do your homework, right? Give us an
Right.
administrative record that actually supports adding a citizenship question and a rationale that matters. And so similarly, I assume that in future administrations, if there was a desire to add a question, if that desire was supported by research and aligned with the administrative record, one could add other questions. That just wasn't this case.
One has to wonder that even though the Supreme Court said the citizenship question could not be included, whether all of the publicity around the controversy over the question might nonetheless result in some people, maybe even a significant number of that 9 million, still refusing to answer the questions. Because I think it probably succeeded at least in creating some fear among many that the census was something to be scared of rather than something to be honest about. I guess we'll see as it unfolds. Jocelyn, can I turn to you? While the census case made all the headlines this year, sometimes it's the cases that don't make all the headlines that are nonetheless quite important and significant. One such case this term was a case called Keizer against Wilkie, which dealt with issues of administrative deference and stare decisis, two big issues in the Supreme Court these days. Can you tell us a little bit about this case and how the court ruled and why it was an important case?
I'd be happy to, but first I have to thank the audience, because when you mentioned during your opening remarks that there was going to be a discussion of an interesting case about administrative deference, nobody laughed. So thank you for at least being open-minded about whether this was an interesting thing. So this case involved a fairly obscure provision of a regulation promulgated by the Veterans Administration about eligibility for veterans benefits and what kinds of documents the agency was required to consider in evaluating eligibility for those benefits. And the question before the court was, what level of deference should be given to the VA's interpretation of its regulation? Its regulation said simply, use relevant documents. Well, that obviously doesn't give very much guidance, but the agency had then said, well, we think that the category of relevant documents is much smaller than what the person who was petitioning for veterans benefits thought that it should be. And so the question was, is this an appropriate interpretation of a regulation that the VA had put into place? Do you find this fascinating yet? So the Supreme Court has a long history of assigning different levels of deference, different levels at which a court is obligated to give some credence to an administrative agency's interpretation, depending on the nature of the administrative issuance. So there's one standard that applies when agencies do notice and comment rulemaking. There is another that applies when they do informal, non-binding guidance. And then there is something called our deference, not O-U-R, but A-U-E-R, based on a case that was decided some time ago, which said basically when an agency is just interpreting its own regulation, a court can only overturn that interpretation if it's plainly erroneous or inconsistent with the regulatory intent. So that's a pretty deferential standard under which, even if the court disagrees that it's the best interpretation of the agency's regulation, it doesn't have the authority to overturn it. Now, I think, it's sort of like, and I'd be interested in the views of con law scholars on the panel, it strikes me that this is a little bit angels dancing on the head of a pin and like levels of scrutiny under the Constitution, that you can say, is it strict scrutiny, is it intermediate, is it rational basis? Ultimately, if you're a legal realist, what you may think is the court's going to decide if it agrees with whatever it is the agency did, and then say that it's applying the appropriate level of deference to be able to get to the substantive result it wants to reach. But that said, we are a government of laws, or have been historically. And the court does have principles in place. The reason that this case was so significant is that I think court observers thought that this was going to be the opportunity for conservative justices to start dismantling the administrative state by limiting the deference that would be paid to agency interpretations of the law. As you know, Congress passes these broad statutes that often have words like relevant or appropriate or reasonable, and Congress doesn't define what those mean, and so agencies fill in the gaps with their regulations and with their guidance documents. And those kinds of agency actions have been critical across the board to ensure that regulated entities understand what their obligations are and individuals understand what their rights are. So whether it's environmental regulation or labor regulation or health and safety regulation or education obligations, those are things that are spelled out in extensive regulations. And various people were hoping that this would be the opportunity for a majority on the Supreme Court to try to rein that in and to say, it's a court that decides what the law means, it's not the agency. So interestingly enough, those who wanted the court to move in that direction lost in this case, another somewhat surprising result, because the court maintained a level of deference that gives more credence to agency interpretations than the conservatives would have preferred. They put standards in place so that it's not a standardless approach, and hopefully that will lead to greater consistency in the ways that this level of deference applies. But the majority declined to overturn the principle of deference, and Justice Gorsuch wrote an extensive dissent, or concurrence, because they ultimately vacated the agency's determination and remanded. So he concurred in the judgment, but his rationale was to say, the court is pulling a fast one. It's overruling this principle of deference, but not saying so. And they'll see that this is unworkable. This case will be back, or a case like it will be back, and we will, at some point in time, overturn this idea that the agency is the entity that gets to say what a particular statute or regulation means. The interesting thing about this is that it's widely perceived that the Chief Justice, Justice Roberts, was the determinative vote in this, and his concurrence rests on principles of stare decisis, abiding by prior court precedents. That's an interesting place for him to have ended up, because it does suggest, as some people have noted might be possible in a host of contexts, that he is an institutionalist and cares about the institutional credibility of the court, and whatever his own personal analytical preferences might be, that when it is a question of overturning a long-standing precedent, he may be hesitant to go in that direction. If that's the case, that can bode well for a number of issues that are coming before the court this term.
Justin, do you feel that, should we take from Keizer versus Wilkie that the battle to dismantle Chevron deference and deference to administrative agencies is over?
Absolutely not. I think that there will continue to be cases that are brought before the courts to try to undermine Chevron deference, and that, of course, is the highest level of deference that an agency regulation gets. And I think what numerous justices on the court would like to see is a principle that is basically like Skidmore deference, for those of you who know these cases, which basically says, yeah, we'll take a look at what the agency has to say, but ultimately we get to decide how persuasive it is, and we, as a matter of first principle at the court, get to interpret the underlying statutes or regulations. I think, you know, they're going to continue to try to chip away at this, and in fact, there was a case earlier this term in which the court signaled that it might be prepared to look at whether Congress has as much authority as we have all thought was the case to delegate responsibilities to administrative agencies to promulgate regulations interpreting statutes. And if the court says that there are constitutional limits on Congress giving agencies this power, that will be a real sea change in the administrative state that, you know, I think we're just going to have to keep watching.
Curious if any of the panelists have any thoughts about what would be the impact of overturning Chevron deference or eliminating that form of deference. Would it make a big difference in how government operates? Would it have a big effect, any of you?
Well, I mean, I think the Keizer case itself is interesting, because I think part of the Chief's point was the gap between what Kagan is saying and what Gorsuch is saying is not that great, which I think is your angel's dancing on the head of the pinpoint, right? Does our deference really matter? Or another way to interpret what happened there is, are the justices who are more inclined to defer operating in the shadow of concerns about conservative justices wanting to move further and faster on this issue, and therefore will be less inclined to defer in some closer cases. So I think there's a question about sort of how big the impact would be of overruling these cases like Auer and Chevron, and how much of this is about standards that are not doing as much work as we might think they are. And there's also a question in my mind about when we think about administrative agencies and the deference to which we owe them, not all administrative agencies are the same. So we can think about cases where you have, for example, the Board of Immigration Appeals, a highly politicized, not particularly professional body that makes lots of decisions in the immigration sphere. Maybe we don't need to defer to them. Maybe courts oughtn't be deferring to them in the way that they do under these doctrines. So I think it's interesting. So it cuts different directions for people of different political persuasions, and it cuts in different ways in different contexts. And I think that's important to note when we're thinking about what deference means. So A, I guess we don't know how much work the standards are doing, and we'll see. And B, I think when we think about the administrative state and questions of deference, sort of which way that cuts can be complex.
Jennifer, can I ask you? I mean, some people argue, and I suppose that's my tentative view, I'm not an expert in this, but at least some people do argue that there is no such thing as an apolitical agency or an apoliticized agency. Either the agencies are the influence of elected officials, or whether it's through Congress or through the president, directly through the president, maybe through Congress because Congress has used oversight enough to browbeat them in submission, or they may be captured by industry, or if they're not captured by anybody, they're captured by somebody. It could be them, it could be either their leaders or the rank and file, who being human beings have their own ideologies. So is there really a sense in which some agencies are just professional and apolitical and just apply objective expertise, or is it really politics all the way down?
We could ask the same question about the courts, right?
No, I think that is absolutely right. That is absolutely right. But so then the question is, of these political actors, who is the one who should make decisions in deciding how the law is to be interpreted? Historically, we've said it's courts, but maybe worth changing. But I'm not sure we should change it on the grounds that somehow agencies are more apolitical than judges. Maybe not less, but I'm not sure why they're more.
Right, no, and I think it is difficult to kind of think of the unpolitical administrative agency. But I do think there are reasons for deference, right? There, in the sense that if you have a body that is acting within a sphere where they do all the work, where they supervise the cases that come up, where they supervise the subject matter area, there are reasons to defer to people that sort of toil in the field and have the expertise in the area. I think that has been the kind of traditional reason, not so much that they're apolitical as that they have a level of expertise to which we defer in certain contexts. And then the question is, how real is that and how important is that? I think those are the questions that these cases
But that's actually
now.
one of the things that Justice Kagan included in her opinion, saying, we are upholding this idea of deference, but it's not a blank check. You have to look at the nature of the issues. So, for example, she says, if it is a very technical issue that is something that scientists or other highly educated professionals in a particular field need to weigh in on, that is something where deference may be more appropriate than if it's a general conversation about what is the best policy here. So if you look at environmental regulations, or you look at the FDA, which sets standards for evaluating the safety of food and drugs, I think courts are in a less advantageous position to second guess whether the standards that the scientists at the agency have adopted are in fact consistent with Congress's intent than they would be if the questions were more common sense or policy judgments.
Justin, can I ask you, you mentioned that Justice Gorsuch thought that, or argued that, you should just overrule it rather than cutting back on it. Do you agree that the majority did cut back on it? So was it just pure stare decisis in the sense of, yes, it's been the law, we stick with the law, or was it something of a retreat?
I think there's been a lot of debate about this, and in fact, Justice Scalia, who wrote the original Auer decision saying, give deference to agencies, later really rued that decision and thought better of providing agencies what he thought was uncabined discretion to do whatever they wanted. So I think this was really an effort to set some clearer standards for this, whether it's cosmetic and doesn't end up carrying the day in any case, or whether it was more of an effort to say, yeah, we get it. This precedent has sort of gotten out of control and nobody really knows what it means. So we're going to impose some standards that people didn't think applied before. I don't know.
Dale, can I ask you, I'm just curious what your reaction is to the thinking about Chevron deference, especially after your experience this year with the Census Case and the Commerce Department, where a big part of your argument, successful argument, was that the Commerce Department couldn't necessarily be trusted to make the decision about what should be added to the census or not, or at least in this case, there's reason to be skeptical. And one might imagine a justice who is a big believer in administrative deference saying, you know what, we defer to those agencies. The Department of Commerce is the ones they're responsible for setting up the census. So I'm just curious if your views on this might have been shaped at all by the case that you were involved with this year.
Well, the precise legal issues involved with Chevron deference are a little different than the ones in the Census case. There isn't a question about sort of deference to an interpretation of law or something like that. But I did think it was interesting that, as the debates have played out about how much rope courts should give to administrative agencies, that the sort of left-right axis kind of tilted in this case, right, with conservatives who are generally very skeptical of administrative agencies sort of bending over backwards to try to just conceive of some reason why the Commerce Department may have wanted a citizenship question on the census, separate and apart from the actual record of what the Commerce Department was actually considering and whether or not these things would actually, whether or not these rationales could actually be served by a citizenship question. Just the sort of hypothetical possibility that if you squinted, maybe there was some way that this other rationale that no one at Commerce ever mentioned might be served. I did think that was kind of interesting. And yes, folks on the left who have argued for deference to administrative agencies wanted to scrutinize Commerce with a little bit more of a magnifying glass maybe than administrative agencies typically get. That being said, this was kind of an unusual case with some pretty unusual facts. Not only did the publicly stated rationale have almost no connection to the actually had no connection to the actual decision-making process that the Commerce Secretary engaged in, but even on the merits, you couldn't find a single voting rights lawyer who thought that having this question on the census would make their lives easier in some way. So yes, the sort of left-right tilt played out differently, but I think this case was quite unusual.
Eugene, the court decided a couple of big First Amendment cases. First, the Establishment Clause case, American Legion versus American Humanist. Can you tell us a little bit about that case?
Sure. So it all goes back at least to 1989, when the Supreme Court, led in this instance by Justice O'Connor, though she got for a while a majority on the subject, took the view that government speech endorsing religion, or in theory disapproving of religion, having either the purpose or effect of doing either, is unconstitutional, violates the Establishment Clause. So this isn't tangible discrimination. We deny you these benefits or we grant you these benefits, or we exclude you from office or something like that. Rather, it's about symbolism, although symbolism, of course, is important. It's certainly important to many people. So the court held this is unconstitutional. There were a couple of major rationales offered. One that Justice O'Connor often stressed, which is that it makes religious minorities feel like outsiders when the government is taking a view that supports the religious majority. And another that Justice Breyer offered, and ended up being the swing vote on, at least for a while, in the Ten Commandments cases about 15 years ago, was that the endorsement test properly applied diminishes political divisiveness along religious lines. What the test very quickly ran into from pretty much the outset is that American history and traditions, like I imagine the history and traditions of probably every single nation on earth, are very closely linked to religion, generally the religion of the majority, and in ways that it seems very unlikely that the court is actually going to give it up. One example is in this very city we live in, Los Angeles. Some people think it's named after the angels. It is not. Whom is it named after?
Nuestra Señora de las Maravillas.
Exactly. And in English?
Our Lady of the Angels.
Who is?
Queen Mary.
Virgin Mary, that's right. Medievalist, my brother's a medievalist. He says he was on these discussion boards all the time. We're talking about the BVM, Blessed Virgin Mary. But you know, that is a legacy, of course, of the Spanish settlement of the Southwest. But you see that in Providence, Rhode Island. You see that in the Declaration of Independence. Not just with a vaguely deist thing that some people like to focus on, creator and nature's God. That's the opening paragraph. If you look at the closing paragraph, it talks about the Supreme Judge of Nations and divine providence. That's not deism. That's not the watchmaker God. This is an interventionist God that is part of this fundamental document. In Star Spangled Banner, there's a passage, let this be our motto and God is our trust. These things aren't going anywhere, right? The Supreme Court isn't going to strike that down. And in fact, when the issue came up to before the court in a relatively recent religious reference, dating back to the 1950s, under God and the Pledge of Allegiance, the court punted it on procedural grounds, but Justice O'Connor felt she needed to kind of explain where she would have stood, and she said, well, that's not endorsement, because it's just ceremonial. It's actually using religion for patriotic reasons, rather than using patriotism, I suppose, for religious reasons, except it really was pretty clearly when you say one nation under God, you are endorsing one particular theological view that there is a God. It's just the court was unprepared to do that. And the court was likewise unprepared to do that on the facts of this case, which kind of, by themselves, you hear the facts and you think it's unlikely that a court is going to strike down what? A World War I memorial, which like many memorials of the time, not like the majority, but like many, involved a cross. And it was a cross that was not by accident chosen as a cross, America being now, but especially then, a predominantly Christian nation. But it was pretty clear that it was not sort of seen as a way of paying homage to Jesus. This was something that was understood as a war memorial, sat there in an increasingly busy Maryland intersection for 90 years, basically. And then there was a lawsuit, and one of the remedies that was sought was to dismantle the cross. That's not quite like the Taliban dynamiting the Bamiyan Buddhas, but you see sort of the sense that the court is unlikely to use the Constitution to dismantle things that are longstanding traditions. So the court basically, by a pretty solid majority, 7-2, upheld the cross. And the 7 were the conservatives plus Justices Breyer and Kagan. But the exact test, and it also, by a majority, at least 6 justices, jettisoned the endorsement test. So the endorsement test, it makes it easier for me now when I teach the class. Used to be I had to teach the endorsement test, and it was just very difficult. Now it's difficult in a different way, but at least I don't have to teach the endorsement test anymore. The majority said basically that endorsement was not a proper reading. But what is it instead? So what we know, just as a precedential matter, and this is important not because it binds the court. I actually think that just like, even more so than regulations, precedents, conservatives like to talk about precedents when they're conservative precedents, liberal when they're liberal precedents. Maybe, rumor has it, Justice Harlan, who left the court in 1971, really believed in adhering to precedent very solidly. But when it really deeply hits them where they live, most justices are not going to care that much about precedent, but lower court judges do care a lot about precedent by and large. So basically the test is now, anything that's old, we don't know exactly how old, but if it's old, at least dating back to the 1920s, maybe the 1950s, probably at least to the time before the court tried to really aggressively enforce these rules, and that doesn't seem to overtly disrespect some minority group. That's one thing that the plurality ended up being a plurality on this stressed, that's okay. So for those things, the focus is more on tradition and on history. Either the monument itself is old or is part of an old tradition. That's constitutional. Now, some justices would have gone further. They would have completely they would have said completely basically the government, all bets are off when the government is speaking. And a related question was, what about this Lemon v. Kurtzman test, which you may have heard of, which for a while was talked about as the test for the Establishment Clause, although it's been pretty clear for decades that the Establishment Clause law has splintered, probably correctly, into a whole bunch of different subtests, rather than the Lemon test being that important. There were 3 justices who would have jettisoned Lemon basically altogether. But not a majority. So what we have is, we have no very clear ruling about the test for new monuments, new religious symbolism, and new, not just monuments, but speech, holiday displays, and such. But if something is old and traditional enough, that's constitutional. Now let me just put in a matter of personal privilege as somebody who's about as far from a Christian as you can get. I was born ethnically a Jew, and I'm religiously an atheist. My parents came from Soviet Union. Communism they had no truck with, but that whole scientific atheism thing, that made sense to them. So I have no personal affection for crosses as such. But I will tell you, my sense is, and I think this was what helped drive the move on the court, is if you look especially at this focus that Justice Breyer had stressed, which is an attempt to avoid divisiveness. My sense is the endorsement test caused much more divisiveness along religious lines than it cured. That for people like me, for irreligious people, it would actually cause more hostility and more likelihood that the majority, which remains religious in America today, would be hostile to atheists as people who are trying to more or less dynamite, metaphorically, American traditions. But what's more, it brought up every Christmas. There was this constant drumbeat of litigation. Well, what about this? What about that? I can't see how there was anything there that was religiously healing across religious divides. If anything, it kept opening up the wounds and ripping off the scabs. So my sense is what will probably happen is that this will diminish the total amount of Establishment Clause litigation. Some people might be quite upset by that because they really don't like these religious symbols. They wanted some means of getting them set aside, although if you look at their success rate, it actually wasn't that high from the get-go. But my guess is it's going to kind of cause some more calmness, whether or not in the right direction in these debates, and somewhat less religious divisiveness, especially when the holidays come.
Curious if members of the panel have any thoughts about this, sort of looking at history and tradition as your answer here. One thing that occurs to me is that might end up really privileging Christian religions, because the symbols that are the old symbols are the Christian symbols in a society that's becoming more religiously diverse than it perhaps once was. And if history and tradition matters, and not, then I wonder the newer monuments that might reflect the religious beliefs of a changing society, it'd be harder to find constitutional.
So I think if you look objectively, what it privileges is monotheistic references to God, generally speaking. That is the dominant thing that had been around. In part because in America, around the time of the framing, there was sufficient religious diversity within Christianity that, generally speaking, talk of God was thought to be very all-inclusive. But once you got any more specific than that, there wasn't really a lot that would be politically viable. So as a consequence, I think what you're going to find is a lot of the things that are made clear are things that are in some measure loosely shared among the monotheistic religions. And it's true that somebody who is a Buddhist or a Hindu or an atheist might say, wait a minute, what are these 10 Commandments doing there? What's God doing in the Pledge of Allegiance? But at the same time, this is one of those things that, yes, if you're going to have some sense that the traditions of a people and that the historical documents, the Declaration of Independence, the preambles to state constitutions, are not going to get swept aside by judges in the name of an establishment clause that almost certainly was not understood throughout most of American history as sitting on the side. So I think those would definitely be privileged. It's also true that there are going to be some things that are more likely to be allowed. Maybe there'll be a return to creches come Christmas. Maybe there'll be more of these cross monuments that are upheld, although in recent past they've been mostly upheld. And it's true. My view is, does it tell me I'm a religious outsider? Yeah, but I am a religious outsider, right? You look at the stats, that's the way it is. And once Once Christians become a minority, then politics being what it is, there'll probably be various kinds of compromises. For example, one of the cases that was upheld in 1989 was a Christmas tree, a menorah, and a sign praising liberty. And Justice O'Connor said, well, in context, this is so ecumenical that this is not an endorsement. But really, the context was also a political context. That, you know, government officials usually aren't terribly keen on fighting these culture battles. Sometimes they are, but sometimes they try to be as all-encompassing as possible. So I think in practice, you're right that that'll happen in some measure. My sense is not a lot will be lost as a result.
Eugene, can I stick with you and ask you to move on to the other part of the
Sure.
First Amendment, the free speech clause, and talk about the Yanku versus Brunetti case?
Right. So this turns out to be, it's kind of lurid facts, right? So there is this trademark that everybody understands people will pronounce whether outright or in their heads will pronounce fucked. Because that's how it's spelled, right? F-U-C-T. No, says Eric Brunetti. No. This is F-U-C-T. That's the way I mean pronounced. Nobody believes that. Everybody understands that this mark that Brunetti wanted to have registered was something that was deliberately meant to be kind of edgy because it's still understood as something vulgar. And the question here was, when may the government deny certain benefits to speech based on factors such as whether it's vulgar or scandalous or immoral? That turns out to be a tremendously important question. I was just testifying at a congressional subcommittee hearing where there was a discussion of whether there should be a tax exemption denied to supposed hate groups, whether charitable tax exemption should be denied to supposed hate groups. So this is another example. This is in trademark registration, but structurally it's very similar. Nobody is saying, at least at this point, ban the hate groups. Rather, what they're saying is deny this particular benefit, this kind of subsidy. There it's a tax subsidy. In the Brunetti case, it was basically a subsidy in the form of better enforcement, stronger enforcement of trademark protection. So the Supreme Court in the earlier case that the Dean mentioned, Mattel versus Tam, said, well, the government can't deny it in a viewpoint-based way. That case involved a ban on derogatory and disparaging marks, which the PTO Patent and Trademark Office used to reject the mark the slants on the theory that that was derogatory to Asian Americans. Interestingly, the owners of the mark were an Asian American band who were conscious of the fact that it had at times been used as an insult and were trying to reclaim it in some measure. In any event, the Supreme Court there unanimously said that is viewpoint-based because you're going after derogatory views, especially of racial groups, but of others as well. That's unconstitutional. So the question is, when can the government engage in content-based but viewpoint-neutral denials? Those of you who've taken First Amendment law know this is an issue that the court has been struggling with at least since the 1980s and in some measure even well before then. And what happened in this case is that the court did not resolve the general question of whether you can deny trademark protection to vulgar marks, but said this particular statute, by banning scandalous and immoral marks, is viewpoint-based. Partly because there's a track record of the Patent and Trademark Office applying it every which way, but seemingly applying it in part based on whether they thought these marks conveyed bad ideas. But partly because the terms scandalous and immoral are things you usually, at least would often use to refer to views. You can have immoral ideas, you can have scandalous ideas. So the court said that is unconstitutionally viewpoint-based. And what if it were different? What if there were a ban on vulgar marks? What if it were like the 7 dirty words that the court upheld by a bare majority in the FCC v. Pacifica Foundation? There was a limit on their use on the radio. The majority, per Justice Kagan, deliberately said we're not resolving that issue. 3 justices, interestingly, Chief Justice Roberts, Justice Breyer, and Justice Sotomayor, so not what one normally think of as a standard ideological divide. 3 justices would have upheld this, but basically by interpreting this as a ban on vulgar marks. And Justice Alito concurred, saying basically, if it were a ban on vulgar marks, sure, no problem. So 4 justices looked like they would be in favor of upholding, not necessarily in favor of the ban, but would uphold a ban that was content neutral if they thought it was, content based if they thought it was viewpoint neutral. And a ban here, I mean just ban on registration, denial of this benefit rather than outright restriction on speech. Whereas the remaining 5 justices didn't really opine. So what do we get to take away from this case? So first of all, you have pretty strong support on the court for policing the government's denial of benefits, especially if it's part of a very generally available program. That if it looks like it may be even borderline viewpoint based, then the court says that's impermissible. Even when the government is not banning anything, but just not giving a certain benefit, that can't be done on a viewpoint basis. But as to what is done with regard to restrictions on vulgarity or other kinds of restrictions like that, that's something that we don't yet know the answer to.
Excellent. And Dale, can I ask you about a case that you're familiar with that also sort of had First Amendment implications, which was the partisan gerrymandering case. One of the arguments in that case was that this was that partisan gerrymandering actually had an impact on speech. Can you tell us a little bit about that case and what the court decided? This was an issue the court had been dealing with for some years, right?
Yeah, that's right. So just to provide some context, over 30 years ago, the Supreme Court held that partisan gerrymandering, in some contexts, that is drawing district lines for partisan ends, if it became so extreme, would violate the Constitution. But not this partisan gerrymander that we're being asked to rule on today. We think that one's probably okay, go away, right? About, I think, 16 years later, another case reached the Supreme Court in the early 2000s. And again, the Supreme Court did not reject the notion that a partisan gerrymander could be so extreme as to violate the Constitution, but declined again to find the redistricting plan at issue in that case as an unlawful partisan gerrymander. 4 justices at that time said they would get the Supreme Court out of this business entirely. But this is ultimately, fundamentally, a political question. There's no objective, manageable standard that courts can apply to draw the line between sort of ordinary consideration of partisanship in the line drawing process, which is a fundamentally political act, and when that process becomes so infected with partisan considerations that it becomes unconstitutional. Justice Kennedy was the 5th vote there to uphold the plan at issue, but to hold out the notion that partisan gerrymandering could still be found unconstitutional at some point. And this case is probably the case in which Justice Kennedy's departure and replacement with Justice Kavanaugh had the biggest impact. Because for over a decade, good government organizations, voting rights advocates, we're searching for that test that might capture Justice Kennedy's imagination, that might be the idea, the standard that they put before him where he finally says, yes, that's it. That's the metric that we're going to use to assess whether or not partisan gerrymandering is unconstitutional. Now, just to be clear, the gerrymanders that we're dealing with today are, I think, far more sophisticated than the ones we had seen in previous decades, thanks to advances in mapping and computer software. In the 2012 presidential election, just to give you, general election, just to give you a sense of things, Democratic candidates for Congress got about 1 million more votes nationally, but 17 fewer votes in the House. You had 6 states that were pretty close to 50-50 statewide in terms of votes for each party. Virginia, Pennsylvania, Michigan, Wisconsin, North Carolina, and Ohio. But in every one of those states, Republicans got not just a majority, but a supermajority of the seats. two, I think, interesting anecdotes from that cycle. Wisconsin, the state legislature there, 2012, Republican candidates statewide got about 48% of the vote and about 60% of the seats in the lower chamber in the Wisconsin legislature. But I don't think that's actually the most interesting fact. 2 years later, in 2014, Republican candidates statewide got 52% of the votes. So they got a majority this time, and once again got about 60% of the seats. And the reason I think that's actually a more interesting fact is what it showed was that the precise quantum of votes that Republican candidates got statewide didn't matter. 48%, 52%, you're getting 60% of the seats, pretty much no matter what, because the gerrymander had grown so sophisticated. North Carolina, where one of the two cases came from, had a, I think, also kind of interesting history. 13 seats in Congress for North Carolina. 2 of those districts were struck down as unconstitutional racial gerrymanders, undue consideration of race in the drawing of those districts. And I want to be clear that the court's partisan gerrymandering decisions do not have any direct implications for that doctrine. North Carolina came back and said, okay, we're going to redraw the maps. We're going to turn off the race variable when we look at the demographic characteristics of the districts. And what we're going to do instead is to try to draw a map with 10 safe Republican seats that will be impervious to any normal swings. And our reason for not doing something different is that it's impossible to draw 11. That's the publicly stated reason of the North Carolina legislature. You probably couldn't ask for better facts, right? If you're going up to the Supreme Court and challenging a partisan gerrymander, the other side's being quite open and honest about what they're doing. But the Supreme Court in a 5-4 decision ruled that finally, definitively, partisan gerrymandering claims are non-justiciable, whether brought under a sort of 14th Amendment, equal protection, discrimination kind of form, or a First Amendment theory, which the plaintiffs had tried in these cases to conceptualize their claims under, in the hopes, I think, of capturing Justice Kennedy, who liked the First Amendment, right? So where does that leave us? It leaves us in a place where federal courts are no longer going to even entertain the idea that a partisan gerrymander might be unconstitutional. Plaintiffs who want to try to challenge these maps on a partisan theory have to try to do so in state court. The Pennsylvania Supreme Court has ruled that there are limits under the Pennsylvania Constitution for that. Plaintiffs have brought a successful case in North Carolina. Trial court ruled in their favor just recently. That case is not going to the North Carolina State Supreme Court, at least not as of right now. So the action will move from federal courts to state courts, but there's really a limit, I think, an upper limit on how many of those kinds of claims can be brought, because I don't think there are that many state Supreme Courts that are interested in hearing those claims.
And Dale, with regards to the lack of a manageable standard, you also mentioned the racial gerrymandering cases. That's another area where the court has said it's perfectly acceptable to have some consideration of race, in the way they might have said there's perfectly appropriate to have some consideration of partisanship in districting. In the race context, they've adopted what, I don't know if it fits the definition of a manageable standard or not, but it survived for 20-something years, or almost 30 years, this idea of no predominant use of race, that as long as race doesn't predominate over all the other factors in districting, then it'll be okay. Why is it so hard to find a manageable standard for partisan gerrymandering?
Well, I don't think it's that hard to find one in partisan gerrymandering. I agree with the plaintiffs in this case, but I do think there are some fundamental differences between racial gerrymandering claims and partisan gerrymandering claims, which may not be apparent unless you are have the bad fortune of being steeped in thinking about this a lot. Racial gerrymandering claims, right, grow out of the 14th Amendment's prohibition on racial discrimination. And these kinds of claims are brought in the context of challenges to single individual districts, where the argument is that in drawing that district, the line drawers considered race too much. They thought about it too much when they were doing it. Like maybe a university in its admissions program might be able to think about race, but not too much, right, in making an individual decision. Partisan gerrymandering claims, at least as they're usually, have usually been brought, are different. They're not so much, when you made this one individual decision, you sort of thought Republican too much, or Democrat, or, I mean, there are no Green Party gerrymanders, but you get the point, right? These claims really grow out of a concern that the system as it's set up is not consistent with a basic, what I think of as a kind of basic principle of democracy, that whoever gets the most votes ought to win, right? That seems pretty obvious to me. But, you know, maybe you don't believe that, but maybe you should agree that whoever gets a minority of the votes shouldn't get a super majority of the power. Maybe that's an easier one that I think we can all agree to. But the point is, it's an argument about the redistricting scheme as a whole and the distribution of power as a whole. And it is harder, I think, to come up with an objective standard that's enforceable by a court when you're looking at a system-wide issue like that, as opposed to an individual decision.
So I wanted to probe on two separate strands in what you were saying. So I think it's perfectly sensible to have a system where the number of seats is allocated in rough proportion to the fraction of the votes. My understanding is that's quite common in many, although not all, European countries. Just not the way it's ever been done in the U.S. Just to take an example of the election, the 2008 election, there was a 53.2 to 42.6% swing in favor of the Democrats, and seats won were 257 to 178, well above the ratio. The ratio was basically 5-4 in the percentage of the votes. It doesn't add up to 100% because of third parties. The seats won were comfortably above that for the Democrats. So it's inevitable that if you have a system which is done by district, which for whatever reasons we've chosen to do it throughout American history, you're going to have disproportions. And it may be even predictable disproportions, that if some people, for whatever reasons, live in districts which are overwhelmingly one or the other, whereas others live in districts that are more 55-45, then that party that happens to have more of the 55-45 districts may end up having easily, even on the natural, might easily have the majority in the legislature, even though in the aggregate it's in the minority. Kind of like when you play the World Series, right? I hear there's one coming up. You Americans, you play this strange game. So I have to say, it's not like I like my old Russian games, soccer and hockey, but at least they have a simplicity to them. Baseball, I've always found to be very odd. But one thing that doesn't seem that odd is that you play a best out of 7 series, and it could be that some team wins 10-0, 8-3, 7-1, 3 games, and the other one wins 6-5, 4 games, and then that latter team wins, even though it may not be the better team in some abstract sense. So I think that's one thing that I don't think that any such system would cure. Now, I was actually on the briefs in one of the cases challenging that, saying the problem is the deliberate attempt, and that's, I think, what you were getting at in large measure, the deliberate attempt to try to skew things. And, you know, I think that's probably right. I think probably the deliberate attempts are probably bad. But I gotta say, when politicians are drawing district lines in a way that's going to affect whether they're going to keep their jobs and their buddies are going to keep their jobs, it's going to be quite a pain to police, I would think, for these kinds of deliberate attempts. Maybe sometimes you'll get smoking guns, but eventually you'll get fewer, but you'll have the same kind of practice. What's your sense of how, as a practical matter? And maybe one solution is just make sure that everybody tries to do it through computer programs where everybody gets to debate the source code, and maybe just have boxes, divide the state into boxes, and not worry about city and county lines and such. But if you don't do that, if you can't find a constitutional principle requiring that, then what's your sense of how one can actually practically implement a no political discrimination rule in a process that's this political?
Well, if you're talking about trying to create substantive limits on what line drawers can and can't do. I agree that that's quite difficult, and I think that's why a lot of the reform movement has actually tried to just create procedural fairness throughout these processes, or nonpartisan independent redistricting commissions that put a pin in
But
whether or
that
not
is
we
clearly
believe
not a
those can be
constitutionally
independent.
available option for the court. The court can't say, as a First Amendment matter, you have to do this through nonpartisan.
Oh, absolutely.
And
I was
again, I'm not
discussing
even sure
this
if nonpartisan
as
is
a-
really going to be that impartial.
Yeah, I was just, noting as a policy issue how we
Right,
might try
right.
to attack
I
this
might be
problem.
all in favor of that.
But-
Probably would be.
But to be clear, the plaintiffs in the two cases that went to the Supreme Court weren't arguing for some sort of strict rule of proportional representation. What they argued was acknowledging that there is uneven geographic distribution of partisans. That if you drew maps kind of randomly without a view to partisanship, you're likely to get some kind of bell curve in terms of what the distribution of seats is going to look like. And it might not look proportional. Democrats these days tend to live clustered in densely populated areas that skew much more Democratic than Republican areas, which are more sparsely populated and don't skew quite as Republican as Democratic areas. Now, knowing that and seeing the social science research on that, I was a little skeptical initially of the claim that gerrymanders today are worse than in previous years. I didn't know if maybe there had been just a different way in residential patterns in our self-sorting that was accountable for the lack of proportionality. But I became persuaded by this computer simulation evidence, which showed that these extreme gerrymanders that we were seeing in some of these states weren't the product of just sorting and chance, but that if you drew something like 100,000 maps in North Carolina, the maps that we got were sort of at the 99th percentile of the distribution, and that to me was powerful evidence of the intent, of the deliberate skewing of the maps. I think that starts to get that sort of standard deviations away from like a normal distribution. That's the kind of evidence that is used in Title VII pattern and practice discrimination cases where you're trying to assess whether or not there's some sort of difference between the pool of applicants and the results from the employment practice that you can't trace to a single individual discriminatory decision. So I think the tools are there, but if they're going to be exercised, they're going to be exercised in state, not federal courts.
Despite the partisan gerrymandering case and the census case, two big high-profile cases this term, I think a lot of court watchers thought that this term the court stayed away from the most controversial issues. I remember when the court was trying to fill its docket for its April sitting in January, and they were picking cases, they had a long list of incredibly high-profile controversial cases they could have taken, from abortion and gay rights and Second Amendment issues that they could have taken for the April sitting, but they didn't take any of those cases. And in fact, the two biggest or most controversial cases that the court took this year, the partisan gerrymandering case was one they really didn't have any control over whether to take. It was a mandatory appeal from a three-judge court. By law, they had to take it. The census case, they didn't have to take that, but that was another case where the administration really pushed the court. We need to get the census out and printed. We need a decision on the census question by the end of June. So with the exception of those two cases, there's the court stayed out of a lot of the big high-profile issues this past year for whatever reason. But one of the rub, if a court avoids the controversial issues one year, is that they come back the next year. And this year we're going to get these controversial cases right as we head into the 2020 elections, perhaps putting the court more centered into the electoral debate than it might otherwise have been. And so turning our attention to this next term, I want to start by asking Jennifer about I think one of the cases that are going to be that's going to be very focused on in the media is the DACA rescission by the Trump administration.
Yeah, I mean, fortunately, immigration is not a controversial issue.
Right.
And not one that is at all important to electoral outcomes. So it's really not that big a deal. But it is ironic now that the court will be sort of faced with this issue as it goes, as we head into an election season. So these are the cases, consolidated cases, challenging the Trump administration's decision to rescind deferred action for childhood arrivals. So for those who don't remember, back in 2012, the Obama administration the Department of Homeland Security issued a memorandum. They said we will be considering certain individuals who are present without legal authorization for deferred action status. And so if you meet this criteria, and the criteria was basically sort of you had to be 16 years old, but not more than 31 years old. You have to have been in the country continuously from 2007 till the time that the program began. You had to either be in high school, have graduated from high school, or have been honorably discharged from the military, and you had to have an absence of certain kinds of criminal convictions. And if you met that criteria, then you could submit an application, a substantial fee, and be considered for deferred action. Deferred action is something that has been referenced in case law, in regulation for some time, and also in some statutes, and it's basically a decision not to initiate a sort of immigration proceeding against somebody. So you get deferred action. And as part of this package, you were also granted work authorization, which is something that's authorized by regulation. Individuals with deferred action can be granted work authorization by the decision of the Department of Homeland Security. So you can then work lawfully. Immigration proceedings won't be pursued against you. And you have to sort of reapply for this every 2 years to have your status sort of reaffirmed, to have the administration look at it again, make another determination that you are still entitled to deferred action status, and that they want to grant it to you discretionarily. So this was a program that did encounter some legal challenges early on. There was a group of ICE agents in a few states that challenged deferred action. Those legal challenges actually just never went anywhere. And for the most part, federal courts found that the entities that were challenging deferred action didn't have standing to bring those suits. But for a variety of reasons, no federal court ever issued a decision saying that deferred action for childhood arrivals was illegal or unconstitutional. So there is sort of this absence of a record of illegality in this program. When Trump was campaigning, you might remember, he kicked it off with some controversial statements about Mexicans. He also, at various times, gave mixed signals about what he felt about deferred action. So there was, on the one hand, there were campaign promises to rescind it on day one. On the other hand, there were promises to sort of do something wonderful for these young people. And so it was kind of unclear what the intentions were with regard to the program, but it was clear that it was endangered. And so when Trump came into office, he actually didn't rescind the program on day one. It took some time. But in September of 2017, Elaine Dukes, then the acting Secretary of Homeland Security, announced that using her authority as the acting Director of Homeland Security was going to rescind the DACA program because it was illegal. And that was the reason given. The administrative record on the DACA rescission consists largely of 3 cases that decide on the legality and constitutionality of a different deferred action program, and that's pretty much it. So this is it's reminiscent in some ways of the Census Case, in the sense that there's not much of a story that the administration has offered about why it's doing what it's doing. And so that was the decision. And the interesting thing about the way that it was announced was they said it's illegal, and so we're going to wind it down real slow. We're going to take applications for another 6 months. We're going to let you renew, and then as you fall out of status over the course of the next 2 years, that will be that. People sued, and a variety of different claims were made in the various lawsuits. 3 district courts enjoined the rescission of DACA, courts in Maryland, in New York, and in Northern California. And the arguments that were made were, there were a variety of them. One was an equal protection argument. The argument was that the administration had expressed outright hostility toward Mexicans and Latinos in campaigning and post-campaigning as part of the presidency, and that this rescission of DACA targeted a group that was overwhelmingly made up of Mexicans and other Latinos. So 85 to 90% of the recipients were in that group, and so there was a sense that the program was not because the rescission was not because the program was illegal, but it was sort of an acting out of this administrative animus toward this group. So that was one set of arguments which had some purchase in some of the lawsuits, including with the Ninth Circuit when it considered these arguments. There were also due process style arguments that a benefit had been extended and that there were certain constitutional requirements for rescinding those benefits. There were arguments around the Administrative Procedures Act and the necessary administrative process that needed to be followed in order to rescind DACA, and so this goes to the record here, and notions that the reason that they gave was sort of this arbitrary and capricious reason, and that more was required under the Administrative Procedures Act to take this away. And all of those arguments, or various combinations of those arguments, had purchase with lower courts. The administration really wanted the Supreme Court to take this issue early, as they've done in a number of high-profile issues. They tried to jump over the courts of appeals, saying once the district courts had issued their injunctions, please decide this now. It's really important for us to begin our slow and gradual wind down of the program immediately. And so the Supreme Court said, no, we really don't want to hear this right now. And so they sort of let the process play out. The Ninth Circuit upheld the injunction, the district court's injunction of the rescission of the deferred action program. And again, the Supreme Court didn't rush to take it on the April calendar either, and sort of kind of pushed it out to the fall. So I think clearly what we're seeing there is some effort to let Congress maybe do something on this issue, a desire not perhaps to get into this fray when political action could resolve this problem. But we have a Congress, a Senate anyway, that doesn't seem likely to do anything about the issue. So the court is now sort of plunged into this and will have to decide the question of the status of these individuals. There were over 800,000 people who initially received deferred action for childhood arrival status. That number has declined in recent years, and you can imagine the variety of reasons why, right? The kind of instability of the program, the concerns about what will be done with the information that the administration has from applicants, the sort of fact that individuals' lives get complicated when they're in this kind of tenuous position has meant that now the number of deferred action recipients has gone down to, I think it's about 680,000 now, so it's fewer, but still a substantial number of our friends, families, teachers, students who are sort of reliant on that status, and the court will be the one deciding what happens with it.
And what do you expect to see from the court?
I don't know. This is a case where I think there are good due process and equal protection arguments, but I don't expect that that will resonate with the conservative justices on the court. I don't think the due process claims will resonate in the sense that I don't think that they think there is some sort of a reliance interest that kind of raises a constitutional stake, although I think there perhaps ought to be. I think the equal protection claims are very real in this case, but I thought they were very real in Trump versus Hawaii too, and I think, you know, and the sort of, it has some of the same flavors as the Establishment Clause. As the First Amendment arguments in Trump versus Hawaii, and we could see that did not have a lot of resonance with the conservative justices. I don't expect this will either. So that really leaves the Administrative Procedures Act kinds of claims, and there I would think this could have been a very easy case for the administration, right? That there are any one of a number of valid reasons they could have advanced for deciding to rescind DACA. They didn't do that, and instead sort of made arguments about legality, which courts are situated to decide. And so the question is this court going to sort of weigh in and say, well, DACA is illegal, or the administration has, you know, provided a non-arbitrary and capricious reason in asserting that this program is illegal, which is a path they could take? Or are they going to be, as the Ninth Circuit was, sort of underwhelmed by the information that the administration has provided in support of its decisions, and do what they did in the Census Case, which is sort of give a half-hearted, you know, go back and do this again? The latter would be a way to buy time, but I just don't know how committed the court is to buying more time on this issue.
All right. And you mentioned Trump versus Hawaii, which is you know, an important case dealing with the travel ban of the Trump administration, but also a case that highlights that in the immigration space, the court has traditionally been very deferential to executive power.
And that the administration here has traditionally made claims about their great authority to enact programs like the travel ban, interpreting statute, which would seem to give it the great authority to enact a program like DACA, where I think there's substantial evidence that the administration has the power and capacity to implement the statutes and regs in this way. So there's a certain irony to the decision they're taking here, which is, you know, oh, we have the power to enact the kind of a travel ban in this, and please don't look at what we're doing too closely, but we don't have the power to enact DACA. So there's a strangeness about the argument saying that we just don't have the legal capacity here to enact what looks like a pretty traditional deferred action decision.
Jocelyn, let me ask you about, I think, what are going to be certainly among the most high-profile cases of the coming term, the Title VII cases on whether discrimination on the discrimination because of sex, as Title VII prohibits in certain contexts, will apply to discrimination on the basis of sexual orientation and gender identity.
Yeah, I do anticipate that these will be quite high profile and deeply consequential cases. So, I mean, just to set the stage, it often comes as a surprise to people that employment discrimination based on sexual orientation and gender identity is not explicitly barred under federal law. So, you know, the old line, you can get married on Saturday and be fired on Monday, has been a source of real consternation because Title VII, the fundamental anti-discrimination law that governs employment discrimination, only bars sex discrimination and does not explicitly refer to sexual orientation or gender identity. In addition, there are 28 states around the country that have no prohibitions on sexual orientation or gender identity. So for the LGBT people who live in those 28 states, which is the majority of LGBT people in the country, they have no protections whatsoever if federal law does not bar discrimination based on sexual orientation and gender identity. So for many years, courts said, no, not covered, can't bootstrap protections against sexual orientation discrimination into a statute that bars sex discrimination. That started to change back in 1989 when the Supreme Court issued a decision called Pricewaterhouse versus Hopkins, which said employers can't make decisions based on sex stereotypes. An employee's failure to adhere to traditional notions about how men or women should appear or dress or present themselves. And that case involved an accountant named Ann Hopkins, who just recently passed away, who was denied a partnership by Pricewaterhouse because they said she was insufficiently feminine in her demeanor. She was too aggressive, she was too bossy, and what the evidence showed was they would not have denied a man a promotion to partnership based on similar personality traits. So they were operating based on sex stereotypes. And that decision, which was now 30 years ago, was the sort of leading edge of a reconsideration of whether old cases that said sexual orientation discrimination is not covered under the employment discrimination laws should be reconsidered. And that re-examination actually took root with regard to gender identity discrimination before sexual orientation was really decided by the courts. And courts pretty uniformly said, yes, if you are discriminating against a transgender employee on the basis of that employee's transgender status, that is the essence of sex stereotyping, because you are saying that this person is not conforming to the way that people of that person's birth sex should appear. By definition, transgender people who identify with a gender different from the one assigned at birth are violating norms that apply to people who are assigned male or female at birth. The development with regard to sexual orientation discrimination was a little bit slower, and the law continues, somewhat surprisingly, to be more mixed. But in the last 2 years, there are two circuit courts, the Seventh Circuit and the Second Circuit, that in en banc opinions said, no, there is no principled basis to say that sexual orientation discrimination is not covered as a form of sex discrimination. And the arguments that they made were, first of all, the sex stereotyping argument, that if an employer discriminates against an LGBT person or an LGB person, it is based on a stereotype that men should be attracted romantically only to women, and that women should be attracted romantically only to men, and that that is a fundamentally stereotypical notion that is not supportable under the Price-Waterhouse decision. The courts also said, on its face, it's sex discrimination because the employer is treating a man who is involved with a man differently than they would a female employee who's involved with a man. Oh, and by the way, you can't look at sexual orientation without thinking about someone's sex. Because in essence, the question is, what's the sex of the person, the employee, and what's the sex of the employee's partner? And then the final basis on which the court, the Second Circuit and the Seventh Circuit said this is discrimination under current precedents was this notion of associational discrimination. And in the race context, it's been pretty clear for decades that if an employer penalizes an employee for being involved in an interracial relationship, that is a form of race discrimination, essentially on the analogous argument that a white person who is involved with an African American is being treated differently than would be an African American employee who was involved with an African American partner. So for all those reasons, the Seventh and the Second Circuits decided that Title VII indeed does cover sexual orientation and gender identity discrimination, even though everybody concedes that that's not what Congress was thinking about in 1964, and that the statute doesn't explicitly say anything on this topic at all. So there were various cert petitions, and the court went to conference on these multiple times last winter and spring. And they put it over again and again and again and again. There was speculation that maybe they did not want to have a hot button social issue during Justice Kavanaugh's first term on the court. Maybe they wanted a lull given the controversy generated by the Kavanaugh confirmation. But for whatever reason, it took them a long time to decide to take these three cases. Two of them involved sexual orientation, and the courts came down on opposite sides. So one is the Second Circuit en banc decision, one is an 11th Circuit decision that found that there is no protection against sexual orientation discrimination under Title VII. And the third is a gender identity case that involves a transgender woman who worked for a funeral home that said, we don't think that it's fair to our grieving clients for them to have the upset that would be generated by having a trans woman being their liaison during these funeral plans. The cases have now been fully briefed. The Justice Department weighed in on the side of the employers in this case, contradicting the position that the EEOC took during the Obama administration. So you have the interesting situation where the EEOC refused to sign on to the Justice Department's briefs in these cases. And I think, there may be a question that comes up about what deference do you give to the EEOC's interpretations, which have not been rescinded, and which said, yes, indeed, sexual orientation and gender identity discrimination are covered by the law. The government's argument, the employer's arguments, the arguments of amici for the employers all amount to everybody knows that in 1964, sex meant biological sex. And this was just nowhere in Congress's consciousness. And sexual orientation and gender identity are different from discrimination on the basis of sex. I think the most radical argument that they make is that Title VII only bars class-based discrimination. And so it is only if an employer is discriminating against the class of women versus the class of men that Title VII provides a remedy. Here, as long as the employer treats gay men and lesbian women the same, it's not sex discrimination. It's sexual orientation discrimination, but because they are not discriminating against a class of women or a class of men, Title VII has nothing to say about this. Now, what the advocates for the employees say in response to that is, that's ridiculous. Two wrongs don't make a right. You can't say that discriminating against men is justified or equalized if you are also discriminating against women. What's going to happen in these cases? You know, I think, like Jennifer, I am deeply uncertain. I think Chief Justice Roberts' respect for precedent gives me a little hope that analytically it is very difficult to distinguish Price Waterhouse and say, yes, we're going to bar sex stereotyping, but that does not extend to discrimination based on sexual orientation and gender identity. It could be that the court will overturn sex stereotyping as a theory, but that would be a much more far-reaching result and would mean that employers were free to impose gender-based roles on men and women of whatever sexual orientation. So I would be surprised if the court wants to go that far. I think that there were lots of briefs filed, amicus briefs filed in support of the employee. More than 200 big corporations signed a brief saying this is discrimination that should be prohibited under the law and reflects the way we run our businesses. There were religious leaders who filed briefs that said this is a form of discrimination that should be prohibited. Of course, there were many more religious employers who filed briefs on the other side saying this would pose significant challenges to our religious liberty interests. You know, I think it is really unclear, but the consequences will be significant. If the court rules for the employers, as I said, there will be millions of LGBT people who have no protections at any level, state or federal, but it will also potentially give more momentum to efforts to pass the Equality Act, which passed the House back in May of this year and would bar sexual orientation and gender identity discrimination across a host of areas: education, healthcare, public accommodations, credit, jury service, housing, the whole panoply of operations in which the federal government has any engagement. If the employees win, I think that you will see a much bigger push for religious exemptions, and you may recall that 2 years ago, the Supreme Court basically punted on a case about the extent to which businesses are authorized to claim religious exemptions from non-discrimination requirements, but there continue to be cases percolating through the courts on this. If the court decides that there are prohibitions on sexual orientation and gender identity discrimination, I think that will create more momentum for courts to be deciding these questions about the appropriate balance between religious liberty and civil rights. And finally, other laws are going to be implicated by this. So Title IX, which bars sex discrimination in education, the Fair Housing Act, which bars sex discrimination in housing, Section 1557 of the Affordable Care Act, which bars sex discrimination in healthcare. I think that the consequences of this decision will resonate not just in the workplace, but across multiple spheres of activity as well.
With most things in the Supreme Court going forward, it does seem like Chief Justice John Roberts has found himself in the center of the court. Seems like he may be the new swing vote. If it's any hope, and I don't know if it is, to the employees in this case, in the Obergefell oral argument, Chief Justice Roberts asked why a ban on same-sex marriage was not itself a form of sex discrimination. Because you can marry John, a man can marry a woman, but Jenny, a woman, could not marry a woman.
And then proceeded to vote
And
against.
then voted the other way. Like I said, I didn't know if there was much hope to be taken for it, but there's at least some openness to the argument, at least. It would be interesting to see what Roberts does.
Well, I mean, actually, that's a larger point that, you know, it used to be when Justice Kennedy was on the court, we all knew who the swing justice was, and we had some sense, because he'd been on the court for a long time, about the kinds of arguments that would appeal. Now, we don't know. Is Kavanaugh potentially a swing on some of these issues? Could Gorsuch maybe be someone to whom one could appeal? We don't know who, and we don't know what the right arguments are, so stay tuned.
Sounds like you need good lawyers to argue these cases. That's a good thing here. We only have a few minutes left. There are some other cases in the coming term that are worth talking about. I think we'll probably skip them unless they come up in the Q&A. There's a big Second Amendment case that Eugene and I were going to talk a little bit about, but it has a big mootness problem. So if we're not going to cover that one case, that's certainly one not to cover because the court might ding it anyway. And there'll be some other big Second Amendment cases to come down the line. We only have a few more minutes. Are there questions from the audience? And if so, I encourage you to please come up and use the microphones that we have on either side of the aisle. And if not, then we'll just leave it to a bunch of lawyers and law professors to keep talking. Yeah, you don't have to raise your hand. You can just come up to the microphone, please.
In the gerrymander cases, is there, I think I read some document, it wasn't mentioned here, of one person, one vote? Does that enter into this at all?
Well, the one person, one vote doctrine is really just a requirement that districts have roughly equal numbers of people. For congressional districts, it has to be as equal as possible. But it has not been interpreted to have any kind of implication as to the composition of the district beyond that.
I see, thank you.
So my question is also about the partisan gerrymandering. I don't need the mic, I don't know why I did that. Also about partisan gerrymandering. So I see that the course majority opinion rests on the fact that there's a lack of judicially manageable standards. Having now been in my third year of law school, it seems like judges love to come up with judicially manageable tests and factors and this and that. And so I'm curious for Professor...
Or unmanageable ones.
Or lack of manageability or anything. And so this is obviously part of Justice Kagan's dissent. But I'm curious for Professor Volokh or Mr. O, if there's any kind of way that you think it could have been more judicially manageable. I mean, we have the efficiency gap, which some courts thought were maybe considerable, but what makes something not manageable or manageable? How do you read the majority's opinion as making sense? Or is it just that in this case, they just didn't like it, so there's never a judicially manageable standard? Does that make?
Well, I will say this is a perennial question, right? And sometimes the courts are willing to experiment with standards, sort of hoping that they get at something that's sort of really deep and central to some constitutional principle and do the best they can. And then sometimes they say, you know, it just isn't worth it. One classic example of that, of course, is the Republican Guarantee Clause, which says that the United States shall guarantee to every state Republican form of government. And more or less, I'm oversimplifying here, more or less the court said, we can't make it an enforceable rule because what's a Republican form of government, what's not, at least setting aside the extremes, which never come up in America. Nobody's tried to have a monarchy within a state, right? As a result, it's something that for a long time the court has said is not judicially manageable. In a sense, the Cross case was, I think, partly influenced by the fact that the court had tried to come up with a judicially manageable standard, the endorsement test, and it failed. And I think there was pretty broad agreement, not just the conservatives, that it was in considerable measure a failure. I think Justice Kagan would have retained it in some measure, but extended it to some other things. there's some situations like with the Fourth Amendment where they say, the Constitution says no unreasonable searches and seizures. We've got to do something, even if unreasonable is such a mushy standard, although they try to give it some meaning. I think here it was a combination that there didn't seem to be much by way of judicially manageable standards, and the feeling that something needs to be done about this didn't seem to be that persuasive to people. I think if there had been judicially manageable standards, maybe one or two of the conservatives might have been peeled away. But a combination of the sense that nothing in the Constitution actually prohibits this, rightly or wrongly, I think one could argue the First Amendment does prohibit it, but their sense of that coupled with, if we do set up these rules, there's going to be constant litigation about every one of them saying they went too far, and then we'd have to try to figure out how far is too far, and we can't. I think that's something that swayed the justices in some measure. Maybe they were wrong, though. Again, I was on the briefs on the other side. I would have liked it if they'd come out the other way, but I think that was sort of their sense.
Hindsight's always 20/20 on things like this, so I'm not faulting anyone for not saying this, but I think probably the day that Justice Kennedy retired, these cases were probably decided. I don't think a majority of the court was at that point receptive to these kinds of claims. If they had tightened up the test here or there, made it a little neater, might not have made a difference. The one thought that I do have is that if there had been a way to try to analogize these claims more to racial gerrymandering claims, to try to make the claims more about individual districts, and make the remedies have been more about maybe redrawing one district or two, where there was just too much consideration of partisanship in the composition of that particular district, rather than something that would have required courts to redraw entire maps. Maybe there was a chance that, with a more modest ask like that, you could have gotten this court, or a majority of this court, on board for something very limited. There's some suggestion of that in the decision from the year before, in the Wisconsin case. Essentially, I read it as requiring plaintiffs to establish standing by living in a particular district where you're challenging that district's lines rather than the plan as a whole. But that's just not the way that the strategy played out.
I think one of the things that's particularly chilling about it, though, is when the kind of where we were before the decision came down was we didn't have a judicially manageable standard. We didn't know what that looked like, but at least there was this sort of sense that if things really got out of control, the court might become involved. And there was probably a way to articulate that in this set of cases, right? Even though it starts to look quite extreme, but at some point, either A, it will be so extreme that we'll need to become involved, or B, the kind of science of figuring out gerrymandering will become precise enough that we can become involved in a useful way. But they didn't take those options, and I think that's problematic because now there's not a sense that the court will step in when things go off the rails. And I think that sort of specter of the court stepping in if things went off the rails was keeping things in control, perhaps in ways that are now, now we just have to see whether the threat of, sort of state court interventions is sufficient, that people are watching their behavior because of that threat. But I think the absence of that is really changing the landscape of what gerrymandering will look like.
Well, they're political checks, partly from state courts, including ones that are elected.
Gerrymandered political checks, though. Right?
No, not necessarily. But on top of that, in most states there are initiatives. I think most states at this point, there are constitutional initiative procedures, and in fact, there have been many states that have tried to solve this through the political process. And sometimes you have a Democratic legislature that's long in control of a state, like in Maryland, the Maryland gerrymander, which is a Democratic gerrymander. Sometimes a Republican legislature, but sometimes the North Carolina Supreme Court steps in. Sometimes the initiative process steps in. So this is a political problem that's been around throughout American history. There is a political solution. Maybe it would have been better if there were a judicial solution, but ultimately a lot of problems have political solutions.
Judicial intervention in the absence of some sort of.
Well, but sometimes threatened judicial intervention actually makes it for more of a problem. It exacerbates the problem because then people constantly try to come up to the boundary. Then there's constant litigation. There are costs to that as well.
Well, we have run out of time, and as the moderator, I'm gonna have to shut it down because the one thing you can't do is keep people extra. So I just want to thank all of our panelists. Join me in a special shout out to our special guest, Dale. Thank you.